Welcome to Miranda Warnings Roundtable, discussing legal issues and current events. I'm joined on the roundtable by Liz Benjamin and Professor Vin Bonventre. Liz is the managing director at Marathon Strategies, a public relations and communications firm, and former host of Capital Tonight, a political and policy show focusing on New York State politics. And Professor Vin Bonventre, distinguished professor of law at Albany Law School and publisher of the New York Court Watcher, devoted to commenting on the U.S. Supreme Court and the New York State Court of Appeals. All right, this week on Miranda Warnings Roundtable, we're welcome back Liz Benjamin and Professor Vin Bonventre. We're going to talk about New York and the New York Court of Appeals. We'll talk a little bit about
the better court.
It's a great court.
In my view,
it's a great court. The New York Court of Appeals is a great court. And we'll talk about a decision that I'm going to say had some notoriety, was somewhat controversial. The decision involving Harvey Weinstein, which overturned the conviction. Vin, just tell us a little bit about what the legal issue was in the Weinstein case. I know people, obviously, what Harvey Weinstein did was deplorable, and people are very offended by it. But for our purposes, let's talk about the legal issues that were at issue here.
Right. How deplorable Weinstein was not part of the case.
Right.
That's not in the case.
I think it was conceded by all seven that he was deplorable.
What's in the case was whether or not the judge should have allowed the prosecution to bring into evidence all this uncharged misconduct, sexual misconduct by Weinstein, and beyond that, it was uncharged sexual misconduct against plaintiffs, complainants who weren't even involved in the case. So it was really removed from the case.
There were specific instances that he was being charged with, but in this case, they allowed complainants to talk about incidents that he wasn't being charged with, that happened either prior or subsequent, that weren't part of this particular case. Right. And the prosecution used those witnesses to show that there was a propensity for him to commit these crimes. And that's under the Molyneux decision, you're not allowed to put in propensity of prior bad acts.
Right, and People versus
I'm sorry, just 1 second. Can we imagine a universe in which this matters in anything other than the Harvey case?
It matters in criminal matters all the time. So let's say you've got somebody that robbed or is accused of robbing a store. And maybe it's questionable. It says, well, we had one person that said it looks like him, it looks like the guy, and nobody else can really identify him. He says he didn't do it. But then you get 3 people from other stores that he's not charged with. They said, yeah, that's the same guy.
That looks like the guy, yeah.
Looks like the guy that robbed my store. So now the jury is thinking, well, he robbed all these other stores. He probably did this one.
Yeah. There's a landmark case that people aren't talking about, written by Benjamin Cardozo, early in his tenure on the court. And it was the same thing. He said, these issues are so tough for the juries sometimes because the evidence is so close. He said the prosecution shouldn't be allowed to short circuit everything by bringing up uncharged misconduct to fill in the gap. And he says that's so inflammatory, and the jury gives too much weight to that stuff. So that's really what the Court of Appeals
is human nature. If the person did it, if you think the person did it, several times before, then even if the proof here is maybe a little iffy, probably did it.
Yeah, and the evidence is like this, but all this other testimony has shown us that Weinstein is sexually depraved, even though those are not complainants in the case, even though those are not specific incidents of criminal activity that are involved in the case. It's just way too much.
Well, I mean, and I'm going to paraphrase, but the majority, which held that the prior bad acts and the testimony regarding the prior bad acts wasn't appropriate, also said it wasn't necessary because there would have been enough proof for a jury to say, in this case, that he did know what he was doing and he did understand the nature of his conduct.
So the interesting thing about all of this is, or the addendum or the footnote or whatever, is that the court makes this decision on a legal technicality and throws it out. He still has a problem in California. I mean, the guy's not going anywhere in terms of freedom, but what have you. Then the legislature steps in their reactive way and is like, we need to close the Weinstein loophole. And so they have legislation that would amend the law to allow evidence of previous sex crimes to be admitted in sexual assault trials to show that the person charged might have a propensity to commit the crime, specifically in sexual assault crimes.
Didn't pass.
It didn't pass as a result, not because of the merits, because I think they were Republican and Democrat. I think it was a bipartisan support. It didn't pass because the governor threw the congestion pricing plan loophole into, the congestion pricing wrench into the mix, and all the air got sucked out of the room and we couldn't do anything else at the end of session.
I should say that. Go ahead.
Well, hold on. From a legal standpoint, do we think that that's not a slippery slope? Understand that crimes of a sexual nature or alleged crimes of a sexual nature are seen as more abhorrent than your average knocking over of the candy store, right? Because we gave the bodega, example where the guy robs my bodega but he looks like the guy who robbed 3 other bodegas and now he must have a bodega robbing habit or whatever. But when we come here, it's like, oh, well, we need to look at the history of an individual because that makes them more into a sexual predator. But that also makes the jury more likely to convict on a crime that perhaps they have a whole string of crimes but didn't do this one. It doesn't seem, that to me seems, as much as we, dislike sex crimes, a slippery slope.
That's the purpose of the rule, to prevent the prosecutors from taking that shortcut, saying, well, we haven't really proven this crime beyond a reasonable doubt, but if we tell the jury that this guy's probably done it several times before, they're going to say, well, this guy's done it before, so he must have done it this time.
Right. I mean, it just seems to undercut the purpose, of what you're looked at. Unless you're charged with multiple crimes, you're looked at for something that you allegedly did not 20 years ago or 20 months ago, but this particular thing that you're being charged with. It seems to me to be dangerous, as much as from an optics standpoint, we all, oh, sex crimes is terrible, we have to do something about it.
Well, I should say that when we're talking about this particular issue, New York State is a little bit of the exception, because most states have in place the kind of law that is being proposed now in the legislature. There's only a handful, about maybe half a dozen states rather, that say something like the Molyneux rule would also
for sexual misconduct.
Preclude, right.
For sexual misconduct.
Would also preclude evidence of past acts. Most other states would, in fact, already permit that. So you mentioned California. The rule in place in California is very different. So the fact that this was overturned in New York doesn't necessarily mean that the California conviction is going to be overturned, and perhaps it would even be less likely that the California conviction would be overturned.
Yeah, when the Congress actually changed the federal law to allow prior sexual misconduct, the Chief Justice at the time, William Rehnquist, was extremely upset. He said, this is just terribly, terribly unfair. But they passed it anyway, and it's not a constitutional matter. Well, it could be a constitutional matter of fundamental fairness, due process. And so even if the New York State legislature and then the governor did enact some law overruling what the court said in Weinstein, the court could come back and say, but look, this is a matter of fundamental fairness, due process, and might not allow such a law anyway. We have the other really interesting thing about this case, 4-3. We're seeing so many 4-3 cases at the Court of Appeals. We used to say with pride that the Court of Appeals is nothing like the United States Supreme Court. where it's divided along ideological lines. We are seeing quite a bit of division along ideological lines.
Well,
At the Court of Appeals.
well, and
we really are.
And you, of course, have studied this, and we'll talk about that a little bit, and I want to talk about it. But if we look historically, we'll go back to, for example, the court during the Judge Kaye's time as chief. She actively sought a consensus, right? So the decisions, not all the time, obviously, but we had a higher degree of consensus. But then when we moved off to Chief Judge Lippman, a little bit less, Chief Judge Lippman kind of welcomed the fact that there might be dissenting opinions. We saw more dissenting opinions during Chief Judge DiFiore's tenure. And so I'm going to say what we're seeing now, we are seeing a lot of 4-3s, but that's not, it's not terribly different than what we saw during DiFiore's or Lippman's, and clearly different than the Judge Kaye administration.
I think you're absolutely right, but I think that's also because at the time that Chief Judge Judith Kaye was in that position, the court started to become much more political because of the governor's nominations to the court, right? So George Pataki, was on this tear about the court being far too liberal, and so he put on judges, and he nominated 5 of them. He put on judges who he thought were much more staunchly law and order and conservative judges. And ever since then, governors have tried to do the very same thing with regard to their particular ideologies, except perhaps for Andrew Cuomo. Nobody knows why the heck he appointed particular individuals on the court.
Yes,
you're right. You're right. I'm wrong. You're right. Yes.
Of a
yes.
bipartisan appointment approach.
Andrew bipartisan? He put on one Republican, Garcia, and that's it.
Right. That's right. That's correct.
Chief Judge DiFiore was at one time a Republican.
Also was a Republican at one time.
She switched to be a Democrat.
Conservatives and liberals to the court.
Yeah, no, you're right. But unlike his father, Mario Cuomo, who would put actual Republicans on the court, right, as many as actual
you're saying
Democrats.
That the people that he put on weren't Republican enough?
I'm sorry?
You're saying that the people that Andrew put on weren't Republican enough?
No. They're just as conservative as other judges on the court who happen to be Republican.
I see.
So we are seeing that divide on the court. But getting back to it, with regard to Judge Kaye seeking consensus, what happened, of course, is, once the Governor Pataki really was bashing the court, and then he started putting nominees on the court that he thought were much more law and order, Kaye was losing the majority. So I think that's one of the really strong motivations for her wanting consensus. She didn't want to be in the dissent too much. She hated to be in the dissent. So she got consensus. And, the complaint, of course, is that a lot of those opinions were pure mush. And Lippman thought the same thing. You didn't know what the heck decisions.
That's what happens when you have to get a consensus of 7 people.
Yeah, you knew what party won, but you didn't know what the principle was. You didn't know what the precedent actually stood for. That was a real problem. You didn't have that problem with Lippman because he said, hey, you disagree, dissent. And then for sure what the majority is ruling, right or wrong.
Liz, do you think it matters? Does it matter to the populace whether we've got a 4-3 or a 7-0 or a 6-1?
No. I think that
does anybody care?
I don't.
Does anybody
to the degree
read
that
these?
anything matters at all, it's if it passes or doesn't, not by the margin that it passes or the decision that gets written or what have you.
Well, other than People versus Weinstein, the general public doesn't seem to care much about the Court of Appeals at all.
Well, they cared.
You ask most people what
there
the
was a
Court of
certain-
Appeals is, they have no idea.
There was a certain hue and cry over the Chief Judge Michigas, right? But I don't know if that was a regular human thing or more of a special interest lobbyists, Latino advocates, labor, etc.
Yeah.
Right.
That was an aberration, though. I mean, what happened with regard to
Yeah.
that.
Well,
More or
we'll
less.
see. We'll see, right? I mean, so Vin, you've written a 6-part series. Six-part. Well, it's a 6-part series, and you went over all the data of the courts with the new chief. And I have to point out, normally I have complete respect for your data, but in part 5 of the 6-part series,
Oh, you're talking about New York Court Watcher parts, yeah.
New York Court Watcher, some of your support, and you quote from the New York State Bar News. We got a shout out from you.
Some of the stuff in the New York State Bar Journal and Bar News has been great.
Explain
It
yourself.
really has been great. You know, I've said it before. Years in the past, the Bar Journal and the News were boring as heck. Not anymore. I don't know whether you had anything to do with it. It's really been terrific. There's really great stuff in there. I mean, there was this interview with Chief Judge Rowan Wilson. It was very revealing. It was great. I forget who did the interview, but it was really
Well,
super.
I know that Susan DeSantis, who heads our communications
she's
department,
she's great.
will
Love
be
working
very
with
happy
her.
to hear that. And I was very happy to see us cited favorably in one of your
When have
one
I
of your
ever
articles.
cited the New York State Bar Journal or News unfavorably?
I
never
don't
have.
recall ever being cited before.
I never
so
have. And if it was you, I would gladly criticize you, but I don't.
so,
And Liz, I'm afraid to criticize
so you
Liz.
studied the decisions. You note that it was hard for you to do an analysis of the data just because of the way the decisions are disseminated. But you're probably the only one that's looking at it this way, so we're not going to change.
In years
how it's
past, in the official New York reports, at the end where it has all the data, it would have data about dissents. It would have data about who's writing the majorities and who would, you would have all that good stuff. You don't have that now. So it takes complete geeks like me to have to go through these, these bundles of data and try to distill from that, what the judges are actually doing.
So, well, it makes your efforts that much more important.
Well, thank you.
So you've done this.
I don't know that anybody gives a darn except for you.
I care, and I know that Liz cares.
Liz doesn't care.
She cares. Look at her. Look at her. Well, so what did you find after all this months of study?
I'll tell you what I found, and some of it is not surprising at all. During the DiFiore era, now Chief Judge Wilson was dissenting a lot. I mean, it was almost constant. Of course, in the DiFiore era, the number of cases that the court would actually decide just really plummeted. And, there would be times, for example, one year I looked at it and Wilson had dissented 37 times. And maybe the court had only decided like 80 cases. He decided 37 times. The fascinating thing, at least to a nerd like me, is that during that time when DiFiore was chief, and it was usually DiFiore, Conataro, Garcia, and Singas, right? Those are the 4 who would stay together. I noticed, for example, that Conataro never dissented. Anthony Conataro.
Why would he dissent if he's in the majority?
Never dissented. Yeah, well, he would join the majority. He didn't have to join the majority, but he joined the majority every single time, or wrote the majority every single time. And then when he became the acting chief, right, there was one dissent by him. Only one. The entire time he had been on the court, only once was he in dissent. Do you know, once Wilson became chief, he's been dissenting more than Wilson? 15 times in 1 year, as opposed to 0, 15. I think that tells you that the direction of the court has really changed. The controlling majority at the court has really changed, for good or for ill. I know I'm happy about it, but it's for good or for ill.
As you noted, during the DiFiore tenure, there was a lot of 4-3 decisions.
Yes.
Now there's been one change in the judge. DiFiore is off,
Gone.
and now we have
Wilson as chief.
Wilson as chief, and we have Associate Judge Halligan. So now there's a 4-3.
Extraordinary picks, by the way.
No,
I mean, you talk about her
course.
resume and credentials and background. My God, what a strong
So
pick.
there has, when it's 4-3, it only takes one for there to be a shift.
That's right.
And so now we've had a shift, and so
Right.
that would explain the reason for dissents. But I want to talk a little bit about the other part of your assessment, and that's the increase in the caseload that's coming before the court, both civil and criminal.
Yeah, and the New York Bar Association newsletter, right? You guys had Chief Judge Wilson saying, he said, if we're going to be a great court again, we need to decide more cases.
Yeah.
He did say that.
Yes,
And
correct.
He's made that plain. He thinks the court really was not deciding enough cases. You're going to be a great court, you need to be deciding cases. And the court wasn't doing that. I mean, the caseload really, from about 250 a year, it went down to 1 year was like 80. I mean, come on.
And now where are we now?
Right now, well, in the last, 103? I think his first term, we jumped up to 103, yeah. Yeah, so half again as many as the very year before.
Liz, do we care?
Yes.
Do we care? Does the populace care whether the Court of Appeals decides 80
Works.
cases or 100 or 200 or?
No, it's interesting. This past legislative session, so at the end of I'm going to get there, just to be clear, I'm going to get there. But every year the legislature, there's some story that's like the legislature passed 3,000 bills, right? Like it just passes this ad nauseum number of bills. And then I believe this year they passed a lot less than they usually did for whatever reason. And like some people would see that purely as a KPI, like I am measuring your success by how many of these bills that you actually move, resolutions, no matter how stupid they are, or nonsensical or not helpful or what have you. So like Vin, I would take issue with this, and this is just personal. Isn't it more like quality, not quantity? Why do we think that the court needs to demonstrate its worth by taking on more and more cases? As long as they make decisions they take cases that are meaningful and they consider them thoughtfully and they issue opinions that are well thought out. Maybe they follow stare decisis, maybe they don't, but then isn't that enough?
I'm going to take, as much as I don't like to agree with Vin,
good.
I'll try to maybe articulate one area where it is important. So, and that's in the area of criminal appeals. And Vin has the numbers, but the numbers were very low. So if there was someone applying for to the court to review their criminal appeal or their criminal case, it was previously very unlikely that
No, I agree with this. I agree with this.
And
agree with this.
now under the Wilson tenure, it's a little bit more likely that.
But
an
what
appeal will be
percentage
heard.
of the cases that they are taking are appeals based on criminal case, and what percentage are just more cases? Do you have that
I
statistic?
think Vin can tell you, but I think what's important is that the number of appeals that have been accepted has increased, and the number of civil appeals has gone up probably not quite as much.
Right, the number of criminal cases has virtually doubled.
Okay, that's positive. But also begs the question as to what the hell was wrong before, but I guess we could leave that aside.
If there's an appeal, then there's a chance that the case will be overturned. And just like we had in the Weinstein case that we talked about.
What David was talking about, in this criminal leave application process, you have every year, each judge gets randomly distributed anywhere from 250 to 300 somewhat of these criminal leave applications. And, if you're lucky enough to get Rowan Wilson, or in the past, Piggott, or Lippman or Robert Smith, you had a fair chance that you were going to be granted an appeal. That doesn't mean you would win at the Court of Appeals, but at least you'd get a hearing. On the other hand, if your criminal leave application went to some of the other judges, for instance, like Garcia, I don't even think he averages one a year.
Well, you put the numbers in your report. It's a little more than one, actually.
Yeah, well, I think there was one year he didn't have any.
It was a little more.
And in the past, there have been other judges like that. So the disparity means that if your criminal leave application goes to a judge like Wilson, you have a good chance. If it goes to somebody like Garcia, you have virtually no chance. It's like a black hole. Garcia is not the only one. There have been others in the past that were just like that. And in fact, when Lippman became chief, he had an executive conference to talk about that and said, you guys need to be granting more criminal cases. Remember, there were real injustices that are done in these criminal cases. And the Court of Appeals wasn't hearing them. But the same thing with civil cases. There were these really great issues, important issues, and the Court of Appeals was not settling the law. When you have millions upon millions of cases being churned out by the New York courts, and then the New York Court of Appeals only hears 80 of them, come on, there are many, many more cases that deserve a hearing by the highest court.
To be fair, though, all of those cases had gone to the appellate division. All of the litigants had their days in court, both at the trial level and at the appellate level. And so...
You're right, but when you get to the appellate division, the poor judges on the appellate division, they're hearing thousands of cases. So they really can't spend the time on each case. They just can't.
And also, to be clear, the appellate divisions are set up differently than the Court of Appeals. You don't just have 7. You've got many more, and they sit by groups of 5, and they divide the cases up. So they have an ability to provide the necessary attention
each of the judges
to the cases.
Hearing a few hundred cases. Yeah.
And so Liz, any other thoughts on how the legislature acted over the past year? I know you said that
vis-a-vis the judiciary.
Just in general, any thoughts?
Yeah, they added judges.
They added judges in family court and civil court.
Signed that into law. Now, do I think that they went far enough to address the historic and systemic backlog in family court? No. There have been numerous, some of which the Bar Association has endorsed, proposals related to reform of the court system that would significantly address some of those problems, which hasn't gone anywhere. I believe it's a constitutional amendment. It would be required. We've never seen an appetite for that. I was surprised. The Weinstein loophole issue sort of popped up towards the end there. And I was surprised that there wasn't a lot in terms of, anything that would really significantly impact access to justice or the legal community in this session.
Well, I think we'll see the Weinstein loophole legislation back again next session. I should point out also that there is a proposal to amend the Constitution to increase the cap on Supreme Court judges. It did pass the one house. It has to pass now in the next session, that house, then it would have to go to the voters.
That's right.
It'd have to go, then it would go to so that's another year and at least 2 years, 2 years away. But that did pass the first step of a constitutional amendment.
Can I say something good about former Chief Judge Janet DiFiore?
Sure.
Because I have to say I loved her personally. I really loved her. I didn't particularly like the way she was voting the last several years, but she wrote one of her first decisions, People versus John. I don't know if you remember that, but she said that when the prosecution presents a DNA analysis into court, that the defendant has the right to cross-examine the analyst who put the report together or someone who participated in putting that report together. You can't just introduce the report. The United States Supreme Court this past term held the same thing. The name of the particular case escapes me right now.
Did they cite to the Court of Appeals?
Of course, they never do. They don't do that. Even if the Court of Appeals, has a much, much better analysis, they don't. They don't cite.
What was the Supreme Court case that?
I'm trying to think of the name, but it was the same thing. It was forensic analysis that the prosecution brought in, but they didn't allow the defendant to cross-examine the actual analyst. They said, "Oh no, the judge said, we don't need to bring the analyst in." And the Supreme Court overruled that. So they basically held the same thing that Janet DiFiore did, one of her first decisions at the Court of Appeals. So my salute to Chief Judge Janet DiFiore.
Very good. And New York State has a history of being ahead of the curve with the U.S. Supreme Court.
Absolutely. We have a tradition of doing that. Yeah. What about the name of the Court of Appeals?
That is something that we really could get in.
It makes no sense, yeah.
It does not make any. And why? What is the history of the etymology of that particular decision?
Well, it's a historical accident,
An accident? They were like, oh, we know. The highest court in the whole nation.
Our trial level courts are Supreme Court.
Yeah.
That's what we'll call our trial level courts. And no one will be confused by that at all.
That's why the citizenry has no idea what the Court of Appeals is.
I don't think they know what the state is. Most people, what they know about traffic court.
All right, next time you'll have to come up with, each of you will have to come up with several names for the change.
Even if it was the Supreme Court of Appeals, like in Massachusetts, the Supreme Judicial Court. Yeah, you could do something like that.
That's too long, Vin.
I think the Court of Appeals is pretty darn good. Even when it's not too good, it's still pretty good. All right. That's my last word.
All right. Liz, Vin, thank you.
So great.
Always a pleasure to see you both. This has been Miranda Warnings, a New York State Bar Association podcast. You have the right to subscribe, rate, and review.